and their injuries, a percentage would have to go to the labor department. But when it comes, the accounts people will not pay, because they will see that the question they will ask is, Doc, look at this. Dr. Hammond gave 6%. The injury occurred in Accra. Dr. Hammond gave 6%. The same injury had occurred in, say, Tamale, and another doctor had given 40%. What do? We cannot go ahead and pay. And because of that, the entire payment is thrown out of jail for years. I'm repeating, these percentages are not discretionary. It is by law. We don't have discretion about this, that this is pathetic, he has lost 2 fingers, this is that, I know this person, I don't know this person. No. This is the law. This is what it's supposed to be. Loss of leg at or above knee, 75%. Loss of leg below knee, 60%. Loss of foot, 40%. Toe or 1 foot, 20%. So sometimes you have to, if the injuries are many, you have to look at this and sum them up. And we all know that you cannot exceed 100%. Loss of remaining eye by one-eyed man, 100%. Loss of hearing 1 year, 15%. Loss of sight of one eye, 40%. You see, so if loss of sight of one eye is 40%, but if you come down, loss of remaining eye by one-eyed man is 100%. So if you are going to give 100%, you have to show that that person has already lost one eye. Has already lost one eye. But if you just write loss of sight or loss of sight in one eye and leave it and you give 100%, that will create a problem. You must be able to show that that person is one-eyed man. Total loss of hearing is 100%. Loss of remaining arm by one armed workman, 100%. Loss of remaining leg by one legged man is 100%. Loss of mental capacity. Loss of mental capacity, 100%. Loss of mental capacity, 100%. So it's on and on. Fracture of upper or lower jaw, 25%. Establishes importance of this law, that is the workman compensation. It establishes no fault compensation system, provide a clear structure for compensation. It covers fatality permanent, partial, temporary incapacity, comprehensive coverage, medical, rehab, prosthetics, everything is allowed to go under this law. Allows indemnity against third-party wrongdoers, accessible, enforceable via district courts. My conclusion is that Workman Compensation Act and the Labor Act promote fairness and safety in the workplace. Employers have a duty to protect workers from harm by providing a safe working environment. At the same time, employees are expected to act responsibly in the discharge of duties. These laws establish clear rights and accessible remedies through legal structures such as the district court. Together, they support the creation of a safe and just working environment for all. The most important is safe working environment. Thank you. Now, the gate is open.
Thank you very much. All right. Thank you very much, Dr. Morris, for such a wonderful presentation. So, ladies and gentlemen, if you have any question, you can either type it in the Q&A session, or you can also raise your hand, then I unmute you so that you can ask our distinguished speaker. So I start with the Q&A. So please, Dr. Daniel Quay is asking, how do we estimate the percentage disability for a simple fracture of the tibia that heals perfectly at 3 months after application of POP? So Dr. Morris, please, should I take them maybe 3 questions at a time, then you answer, or 1 question at a time?
You can take 3 questions.
3 questions, all right, okay. And also, Dr. Ekolamte was wondering if the 5 million cedis is in current cedis, is in current Ghana cedis or the old cedis. I think the 500 came in one of the slides. And under the,
Yes.
okay, that's the same question Dr. Ismail Saki is also asking. And Dr. Ekolamte is asking, does chronic medical conditions such as hypertension, diabetes, and so on also qualify as occupational injury?
Okay, let me ask the last question. It is very, very important. And that is why when I started, I said the medical directors and the managers on this platform should take notes. If I came to work for you, for instance, as a health worker, as a doctor, as a nurse, whatever, and you don't have my basic medicals, you don't do routine medical, and the stress and the nature of my work, I develop chronic disease. You see that from the beginning, it says that the compensation is not for acute injuries. The compensation is not for acute injuries, but other related, work-related injuries, work-related injuries, work-related. So if we are able to show that the nature of my work had led to the development of diabetes, the employer is liable. The employer will be liable. More than 27 years ago, an elderly doctor told me that for him, he had sat down and he had analyzed, done analysis of the situation, looked at various specialties in the health sector, and he had seen that one group of people, specialists, are prone to diabetes and hypertension. You see, he said it.
Yes,
he said
true,
one
yeah.
group of specialists are prone to, I will not mention because he said they are dealing, their work is emergencies. And they are dealing with time. and therefore they are always on edge, releasing hormones themselves, and therefore they are prone to have diabetes and hypertension. And he took me through, mentioned names and asked me, have you seen any elderly person in this department? And upon looking through, I said, oh, okay. But none of them had been able to go and take compensation for such work-related disease.
So you can even claim
it is clear.
After retirement.
6 months.
Oh, okay.
Upon retirement. You don't go, then you come back to say, if you are able to prove that you had that disease whilst you are working, then you are entitled to. I've made this argument over and over again. Look at the midwives using this old fetal stethoscope to be listening to fetal heart burning down. Obviously, they are no wonder they are using neck braces and all those kind of things with waist pains. But as I stated, health workers, we are not told, we are not trained to talk about these things and to seek compensation. But if we fill these forms for other employees to collect compensation, but not for ourselves. Not for ourselves. And when an employee, health worker, is claiming compensation, that employee becomes an enemy of management. I've seen it over and over again. Over and over again. Why is she or he claiming compensation when the injury is work-related? One regional director even insulted me when an employee had been injured, clearly injured, in the course of a duty and need to be compensated. No way, because we are health workers and we are not supposed to collect compensation when we are injured. That is not fair on us. So managers, please take note. And as a manager, you yourself may be suffering from work-related disease or injury. And if you are not allowing your employees to collect their compensation, how can you put in your own claim? The question about tibia injury, that is why I stated that that injury is not permanent and the compensation percentage has been stated clearly on the form. So that compensation is given and it is paid periodically. And then it is reviewed. If you look at section 7, provides for compensation in cases of temporary incapacity, whether total or partial. The compensation may take the form of periodic payment or lump sum, depending on the expected duration of the incapacity and any changes in its severity. So if that injury, the orthopedic surgeon says that injury is going to be healed fully, and he has given time frame, and we know that the level and the limit of incapacity, then that level of incapacity must be paid for. It ought to be paid for. It need not be permanent. So if I break my arm and I can't use it for 1 week, I still have to put in to be compensated. And when the surgeon reviews and says I am no longer entitled, then payment is stopped. The amount you saw was old CDs. But when it comes to such matters, it is referred to Bank of Ghana, and the accounts people are better suited to work on that. So though it is in old cities, it is taken care of under the new Ghana cedis with inflation and other matters. So that is what is done.
Right. Thank you
Yes,
very
next
much.
question.
Yes. So Dr. Joseph Anson is asking if workplace accident occurs and employer sends an employee to the hospital, but employer asks for treatment at a bone setter and seeks treatment from herbal practitioners. That's facilities that are not accredited by Ghana Health Service. Does the employee qualify for a workman's compensation? And Dr. Lapte is asking, is Section 7 of the PNDC Law 187 equivalent to temporary unemployment insurance or benefits? And Dr. Saki is asking, can you please explain the difference between health and safety? They are routinely lumped together into one department at the workplace. Do they describe the same thing or imply different things in practice? He's asking if you
Okay,
can explain that.
let me deal with these three questions. The first one says if someone is injured and the person chooses to go to a herbalist, before, the answer would be no compensation. Before, the answer would have been no compensation. But we all know that today, if you go to LECMA, we have herbal doctors, isn't it? If you go to a lot of district hospitals, we have herbal departments. So that becomes a bit of a problem, a challenge. But if that disease has no herbal alternative treatment and the person chooses to go on his or her own way, then that person is forfeiting the compensation. That is why you will see that the employer from time to time will refer such a person to you, employee back to the doctor to reassess. So if the employer refers the person, the employer refers the person to accredited facility, and the employee refuses, that employee is simply saying that he or she is taking care of himself or herself. And that is what many employers are doing. They have specific hospitals that you need to attend. So even if you went to, it was an emergency and you went somewhere else, your medical report or whatever it is ought to be authenticated by their accredited health facility. So that ought to sink in. An employee cannot take the law into his own hands and decide to do anything and come for compensation or healthcare expenses. There were three questions. I've lost track of the second question.
One question was, is Section 7 of the PNDC Law 187 equivalent to temporary?
No, not at all. This is very specific that I've gotten an injury, maybe swollen face or swollen eye. I can't use the eye and I need to be compensated. You can't say, oh, this eye there, it will resolve within 3 days. So why do you have to fill a form? No. And that is what is causing us at the health sector. And it is causing health workers, even when they go to the bargaining table to bargain for salaries and other allowances, because we don't report injuries at the workplace or work-related injuries. We don't. How many people go to the OPD and get infected? They go to work normal and they come back with severe cold. All these are supposed to be reported, recorded, and measures put in place to reduce, eliminate, or be made to adjust to live with it. But if you don't report, then it becomes a problem. One is asking health and safety. Health and safety. There are two things. Your health and your safety are not the same. You can be healthy and not safe. And you can be safe and not healthy. And what the law is saying is that the employer shall make sure that you are healthy and you are safe. That when a healthy person gets to the workplace, that healthy person should be safe to return home without any injuries. I hope the question has been answered.
Yes, please.
So they cannot be interchangeably. They are not the same.
All right. So
let
me. Yeah. Oh, there are more questions. There are over 90 questions there. So
I told you, Mr. Hammond.
So let me lump these questions together concerning infection with HIV. So some Dr. Wilson and Dr. Martin Atuguba, they asked, how can the staff who is infected by HIV at work be compensated from the law? In as much as what is the compensation for staff who get infected with HIV from needle prick? That's one question. And another one, what is permanent total incapacity and partial incapacity? What is considered a disfiguring injury? That's Dr. Richard asking. And Dr. Lamte is asking, does the 6-month rule apply in cases of death of employee, and how does that compare with employee giving fair wages and compensation, as well as safe work conditions for employee and dependents?
I don't get the last question.
Okay, this is how it reads. Does the 6-month rule apply in case of death of employee? And how does that compare with employer giving fair wages and compensation, as well as safe work conditions for employee? And so, boss, if you don't get it, Dr. Eko Lamte, please, if you're on the line, kindly raise your hand. So after a number of questions, I will let you explain yourself to the speaker. So let me take another question. Dr. Joseph.
Okay.
Come again.
Okay.
So it's left to the last one. Does an employee qualify for a workman compensation if injury occurs on his or her way to work? All right.
Okay. I'll answer the last first. The last one means that the person did not start with us, because I was emphatic. That is why when I read in the course of, so if I give an example, if I've been posted to go to Techiman, I'm posted to go to Techiman. I haven't gotten to Techiman yet to report, and I have accident in Kumasi. I'm on my way to Techiman. I've gotten an accident. It is still in the course of my employment. You see, there was a nurse who had been posted to go to one of the regions, and she had an accident and died. And some of my colleagues were saying that, so I report the way they had in a Ghana Health Service with your compensation. You see, it was, for me, it was absurd. How would that person get up in the morning and say, I'm going to, or Sunyani, if that person had not been posted to that place and that person gets an injury, and the answer is that that person hasn't reported yet, so we don't know where to place that person. You don't know. You are giving that person appointment letter and you have posted that person. That person is on his or her way. So immediately that person leaves, I'm going to work at the ministries and I live at Sotum. When I leave home from Sotum to the ministries and I have accident on the way, it is the duty of my employer to take care of that. It is the duty of my employer to take care of that. So I believe the last question has been answered.
Yes,
Let's
please.
take the first question, that has been has been a problem. Yes, if someone gets injury from needle prick, let's take it step by step. Did that person report that injury? There's a time frame to report that injury. If that person reported, was that person giving prophylaxis? Was it recorded? If you don't do that, if you don't take it step by step, because the law is very clear that even if you get injured and it's not reported within 24 hours, the employer is penalized. So if you had an injury, a break, you must report that injury immediately. And we know that if you report needle break, there are steps to be followed. If those steps are followed and all recorded, prophylaxis given. We have one example that when the prophylaxis was given, the person had severe Stevens-Johnson syndrome, which led to more problems. So such a person is entitled to compensation, is entitled to medical treatment, is entitled to all compensation and all forms of care that that person needs. But if you don't report, if you don't, and one day, you go and do tests, and they say you are positive. Since HIV cannot be gotten through only needle pricks, it will be difficult to associate your disease with workplace injury. I hope we are following.
Yes, please.
Dr. Hammond, I'm saying, talking about needle prick, if you are injured, the law says you have to report, fill a form so that you be compensated. But when it comes to needle prick, we know the steps that ought to be followed. There's a policy. So if all those things have been followed and you still ended up with the disease, if you are HIV positive, it does not incapacitate you 100% until it is fully blown that you cannot work. Then you become 100% incapacitated, that you are paid 100% incapacity. But the compensation for partial will be paid if you are reported and has developed into that. And if you are assessed and the assessment says you cannot work again because of what your status, then you move to 100% incapacity and then you are paid. Are we okay?
Yes, sir. Yes.
Hello. Very good. The next question.
It was about total incapacity and partial incapacity. Yes. And what is considered as a disfiguring injury.
total incapacity, the law says that it's not me defining, no. It is defined in the law. Means such incapacity, whether of a temporary or permanent nature, as incapacitates a workman for any employment which he was capable of undertaking at the time of the accident. And partial incapacity means where the incapacity is of temporary nature, such incapacity as reduces the earning capacity of a workman in any employment in which he was engaged at the time of the accident. So you see, if I'm a footballer, I'm a right-legged person, and now I've gotten injury on my right leg. I can walk, I can do everything, but I can't play football. So 100%. Another person who is not a footballer get that injury. As for him, he's not somebody that even works. His work is sitting down and typing. And therefore, his injury would not affect him being incapacitated. So he cannot go and claim 100% incapacitation. Are we on the same page?
Yes, please. Then he gets 5%.
So it depends. It totally depends.
All right, sir. Okay, so we are moving on. I think Dr. Eko has raised his hand, so if he can expand on his question. So, Dr. Eko, I'm unmuting you so that you can talk.
Yeah, I think my question about the 6 month rule is very simple. In Ghana, there are a lot of migrant workers in Ghana. And in the past, we had the civil war in Sierra Leone and Liberia, where a lot of Liberians were brought in. A lot of them have naturalized and are working in Ghana. For example, the transport, even the recent issue about Galamsey, the small scale workers. Those who were arrested and sent, a lot of them, it was realized a lot of them were migrant workers. So in the case where a migrant worker, because of the informal nature of the sector, and even in the formal sector, there are a lot of migrant workers. Some are refugees and all that, and some are very fluid. So just like the example of the accident, if you have an accident on the way, you are working for, let's say, a transport operator, and you have an accident, or a small scale mine, you have an accident. Your relatives don't know. And by the time they get to know of your death, and then get a representative or necessary documentation or calm down to even prepare for the documentation and submit, it's way past 6 months. What do you do? Does it mean that the person cannot apply for the what we call death benefit or what? And the 6 month rule international best practice in that circumstance, if you compare to even, let's just say, even West Africa alone, and then Africa, and then globally, is that the international best practice to use the 6 month rule either to qualify or disqualify relatives or dependents of a deceased person, death-related bereavement from getting their benefits? Is that the best practice?
Equalante.
Yeah.
It is not the time to claim. It is the time to notify. You can't say that somebody is dead and you can't get anybody to notify. When death occurred, haven't they taken death certificates?
Come again.
An injury occurs. We are talking about notification. It's not the time to claim. You can start claiming later, but the most important thing is notify, the notification. Notification is what we are talking about.
Yeah, that's what I'm saying, compensation. But as I said, in for a lot of American workers and then the refugees and those who are very fluid, sometimes it's difficult to, even the documentation that they have might not be what
Dr. Lante,
Dr.
Lante, we are not talking about documentation or anything. We are talking about the injury being reported. That is why they have put penalty on even the employer to report within 24 hours.
No, I understand what you're saying, but this one, the employee has died. And as the relatives,
yes,
it's incumbent on the relatives to apply for the benefit.
Relatives. We are talking about the
cannot apply within the 6 months. Sometimes even getting to know that the person has died, it's difficult to transmit the information because they didn't inform their relatives. So the information comes late before they can even come and retrieve the body, do the obituary and all those things. And when they are applying for the benefits, so they need those kind of documentation before they apply. And by the time they do that, it's past 6 months. So how does the 6 months to apply? Then it means all those people, effectively, you are denying them of their benefit. They can't get anything. Their relative has died for nothing. Whether the relative was formally employed or illegally employed, was legal or illegal in the country. Because of that, and because of the difficulty in communication and transmitting the information for the relatives to come for the body and do the needful, and also to apply, effectively, you are denying them of their benefits. That's what I'm saying. So I'm asking, is that the international best practice?
Dr. Lamte. Hello, Dr. Lamte. Your points are well noted, but we are not here to debate whether it's international best practice or not. The law has been is there in black and white. What our speaker is saying is notification. Let's just do what needs to be done. If the relatives can take it up through the legal route, if they feel they've been denied. Okay.
Yes.
Thank you.
And that is why I stated that even with the Labor Act, I can choose not to go through the workman compensation. I can choose to go to court straight to sue. And the court for liquidated claim, it is up to 6 years. Dr. Lamte, if I decide not to go through the workman compensation and go to court, I have 6 years to claim for any liquidated claims. I have 6 years. So their rights will not be infringed upon. That is, if that notification had been given. We are talking about notification. Somebody in the course of his employment had gotten injured. Somebody in the course of his employment had permanent injury, disease, or death. That ought to be reported. And there is a penalty if it is not done. It ought to be reported. Dr. Hammond.
All right.
Bring
yes, sir. You noted.
Questions.
Yes. So yes. As Dr. before receiving to the questions, please permit me. Let's allow 2 senior members, Chief, Sir, Dr. Hugo Smith and Dr. Justice Silverkin. Dr. Bifo, please allow the senior members to ask that. I think their hands have been up for a while. And please, let's use the Q&A to note our questions so that we can all have access. Please keep the questions very brief and straight to the point so that the answers can be given. Chief and Dr. Silverkin.
Okay, so Dr. Silverkin can ask his question. Dr. Silverkin, please, can you unmute and ask your question?
Yeah, thank you very much. My hand was really down, but somehow I don't know what happened. I wanted to ask the same question that I'd like to ask. The question is to report, notify. Who do you notify to? For example, if somebody is living alone, maybe the relatives are in Accra, living alone in Kumasi, an employee, then being transferred to Tamale. Then on the way to Tamale, had an accident and died. The relatives have no clue. They've reported to the police. Most accidents will be reported to the police. By the time the relatives got to know about the death of their relative, it's past the 6 months. What do we do in that sense? Because it's only going to a police. The employer self was not aware because employer it was on the way to the new station. Hope the question is clear.
You see, Prof, it is unlikely that an employer is not looking for his employee for 6 months. I have transferred Dr. K to Kumasi Central Hospital, and Dr. K hadn't gotten to Kumasi for 6 months. And the employer is not asking any question. You see, that is why the penalty is on the employer. This thing had happened several times. Say, I agree with you, because there was a situation where one of our employees had mental issues and disappeared for a number of months. And instead of looking for such an employee, we rather removed his name from the payroll that he had abandoned post. So it became an embarrassment for the employer. It's the employer's duty to follow his employee. That's why every employer takes data of their employees, phone number, next of kin, address, and all these kind of things. So if we say that you've sent someone to Kumasi and for 6 months, no employer, nobody has asked. I mean, yes, let it happen. It has happened. But that does not stop the relatives from claiming. As I said, they will have to show that it was beyond their limits. And therefore, it was the duty of the employer that ought to have reported. And the relatives can sue even the employer if they decide not to go for workman compensation and go to court and have their claim head over there. So it doesn't stop anybody at all. The 6 months doesn't stop anybody. Unlikely event that this has happened. It is not a bar. You can go to court. For liquidated claims, you have 6 years, 6 good years to go and file for a liquidated claim. So it is not a bar. What this law is encouraging is that, especially with the health workers, whenever there is an injury, prompt reporting, and the responsibility on the employer to within 24 hours report this to the labor department for compensation processes to start. It is not for nothing that these laws are made, so that one day people not just get up and come with claims which cannot be substantiated. For instance, the HIV example that I gave, if you indeed had another break, you ought to have immediately reported, and then it would have been taken through the system. You went to the ward, infectious disease ward, and you came back and you are not well. You need to report and don't sit down after 10 years. And I used to work on the infectious disease ward, and that will not suffice. It has to be done. The first step is to report. Reporting is very important to be documented.
Thank you very much.
We are clear. Yes, so yes, I'm waiting for Prof. Holbrook Smith.
Yes, Dr. Smith, the floor is yours.
Right. Thank you. I'm not sure if I can be heard.
Oh, you can be clearly heard.
Chief, we can hear you.
Hello?
Yeah, Chief, we can hear you.
We can all hear you.
Yeah, my question is this question of the compensation and percentages. You see, if somebody has had, is a right-handed man, he has had a thumb, he can't work. But then you've got percentages that loss of thumb is a few percentages. The whole person can't work. The same with other parts of his body. Why don't we compensate for that as well? But it's only you see, I've issued a report where the person had a problem with the thumb. He couldn't work at all as a tailor. And then when I said that he's compensating 100%, they said, no, it's only the thumb we should concentrate on. What's the law? How does the law protect people whose little finger or something has been so badly damaged that he can't work completely? It's a whole body. It's a person who's damaged the thumb or the little finger, not only the little finger. What's your view, Ankara? It's nice to hear from you. Well done to have you as a lawyer as well. Nice, long time.
Yes,
Keep it up. Thank you.
That's a long time, sir. Thank you, sir. Sir, you can justify that 100%. The example I gave for somebody, a footballer, losing the right foot. His entire dependence is on the right foot. So if that person loses the foot, though the percentage may say 40%, but that person is permanently incapacitated and that person cannot work. His work has come to an end. And therefore, you can justify that person having the 100%. You must have a backing and proof. Because if it's left open, Prof, it was up to you to show that that person depends solely on that little thumb. And without that little thumb, all the other parts of the body, cannot do anything. And that person had lost his total livelihood. That would be committed to 100%. And the committee would understand. And they would require that you face the committee. And as I said, the specialist colleagues are always giving percentages. They're giving percentages arbitrarily, and they are writing. And I had always also defended that if they had written something that you don't understand, all that you need to do is to invite them. But the problem is that most of us, when we are invited, we become timid, we become intimidated, and we can't defend the report that we've written. Yes, the person has lost just a thumb, but the person's entire livelihood depends on the thumb. And you are justified to give that person 100% and meet the board to defend it. The main issue is the defense before the board. The main issue is the defense before the board. Because if you look at the total incapacity, whether of a temporary or permanent nature, as incapacitated for any employment which he was capable of undertaking at the time of the accident. At the time of the accident, the person was using only his finger that he had lost. So if he had lost that, then that person is permanently incapacitated and deserves that 100% compensation. So, Prof, I hope I've answered your question.
Yes, sir. Let me throw in some more questions from the audience. Dr. Christine Usufrempo is asking if someone develops a stroke with hemiparesis, how is the compensation calculated? And also, question about how do we estimate disability or disfigurement for burns? And the last one that I will throw in is one says for workplace injuries from Dr. Eric Ameyao. Where do we exactly report workplace injuries? Then I think Dr. Aisha Isaka will ask one more. Then we'll switch back after you are done answering. Dr. Brefo.
All right, sir. So, Dr. Ankara, please, can you go through the questions for us, as in the one Dr. Hammond asked?
Okay. You are talking about Dr. Hammond. Dr. Hammond. Hello, Dr. Hammond.
Yes, sir. So one was
I will
on
start with the
calculation for disfigurement or where we report the workplace injuries. Any of them should is good.
Yes. Disfigurement. Also, you see, when you are not sure of the percentage you give, the law allows a board to be set by the labor officer to bring specialists and others on board, at least 3 members, to determine the level of incapacity and the level of compensation to be given. Where to report whenever any injury occurs at the workplace, the first place is the management. You report workplace injuries to the management. And it is not oral. It ought to be written. One thing I've realized with health sector is that we don't like to write. And I told him, the management, I went to administration, I told them, the administrators understand this is that anything that is not written is not there. Memo. At least head of department, if it happened under you, head of department should take the lead to write the memo to management, because everybody under that department is under you and you are responsible for their health and safety. If it is on the ward manager must be able to do that. Theater, same. So that this written complaint will get to management. And when it is written, you will know that it will never get missing in the system. And I will say again that when it is written and typed out, you should have a copy, a received copy. When you send it to management, someone received it and that person signed receipt. Because there's one pen in one of the facilities as we speak, talking about not reporting that she was lifting a patient and had a back injury. Management is refuting it, that that person might have gotten that injury somewhere else and not on the ward. And they are asking if she reported and at what time and to whom. So documentation is very important and it shouldn't be verbal. Let us not forget that those who pay are always finding ways not to pay, especially health sector. Whenever something legitimate to be paid to you, they will invoke auditors and you are not going to get anything. And therefore, you must be able to document this for auditors not to have a room to say they are not going to pay. Every work-related injury ought to be compensated for. Every work-related injury ought to be compensated for. And I've always said that the rudeness that we encounter on our wards in our hospitals is due to the fact that we don't know that even when we are abused, we have to report. And it ought to be recorded. And something ought to be done about it. If we know all these things, we'll not be fighting our own battles with clients on the ward and all those kind of things. And that is what normal Ghanaians do, except health workers. They report their workplace issues and they are compensated, but we fight our own fights. We fight our own battles. pay our own bills, and on and on. And I'm saying today that if we have managers on this platform, they must start taking good care of their staff, their health. At least the basic data, you should have it. Because very soon, the employees are getting wiser. And when they start suing the health sector, they will collapse it. That is if they would also document, report these injuries that need to be compensated for. Everyone is due to be compensated if they had injuries or disease or disability, and it is work-related. Dr. Hammond, more questions. We are waiting.
Yes, more questions. Thank you very much. I think we are really learning a lot. So let me switch to this sector. Someone is asking of
Dr. Brifo.
Yes,
please,
Dr. Aisha.
I was asked to ask my question, please.
Oh, okay.
Before you went to the next one. Yes. Thank you,
me.
Dr. Morris, Anchor, and all senior colleagues on the call. Please, all protocol observed. My question is with regards to the compensation. You know, nowadays we have this prosthesis, okay, that if somebody lost both hands, you can fix them back. Okay, so in the light of that, how do we talk about the compensation in that regard, so that it's not just compensating the person for the total number of years if it is 100%, but actually giving the person the ability to come back to work? You know, how do we negotiate that? Thank you.
Hello, I think I stated that the employer's duty to provide prosthesis, glasses, dentures, and on and on. It is the employer's duty. If you had injury, work-related, and you've lost the arm or something, it is the employer's duty not only to compensate, but rehabilitate and to provide prosthesis. Medical care is part of the employer's responsibilities. And the employer ought to ensure that you are provided with those prostheses. And if they need to be changed, the employer needs to do that. So it is part of the package. It is not just compensation, you are giving some money and thrown away. That is not so. So it is all looked at.
Okay. Dr. Aisha.
And we all agree.
Yes, thank you,
and
Dr.
we all agree that.
So, thank you, Dr. Morris. Yeah, thank you.
Aisha, are you okay?
Yes, I'm okay. I think that maybe I was just looking at the Workman's compensation, those percentages. So it means that you can even negotiate ahead of that. That is just maybe a baseline. And so if the person has
no, not at all. That is why I said that you can even go to court for more.
Okay. Yeah. Thank you.
Dr. Morris, please, let's switch to this aspect too. Mental health too is important. So Dr. Francis is asking, does mental disability aspects qualify for Workman's compensation? And
I mentioned it clearly. Mental health, mental incapacity is 100%. It is there.
Dr.
So they are
Derry
all
is also
compensation, but it must be work related.
All right, sir. Thank you.
It must be work related and not genetic related.
So all that it has to be proven.
Yes, it has to be work related.
Dr. Derry is asking, so for someone who suffered a traumatic brain injury and has some neurological deficit in motor function, which is not necessarily loss of a limb, but reduced function of the limb. How can such cases be tackled?
It is even better because that person is loss of function. Loss of function. It is not the limb that we are looking at. If the limb is gone, it goes with the function. The limb may be there and has the loss of function. So the loss of function is what the law is actually looking at. It is not a physical loss, but actually the function. That is why if you listen to Dr. Professor Smith's the loss of thumb, it is the loss of the function that the person used to apply his trade. And that function is gone. The entire body is there. So if somebody had head injury and it's affected his function, that person may even have 100% incapacity because he cannot function again. And if it is work-related, it is 100%. The whole body is intact, but the function is gone.
So Dr. Richard Atuwo Ampo is asking, is there a category of doctor who can sign for the workman's compensation? And Dr. Gloria Kudria is asking, who pays for the indemnity? Is it the facility or the government?
When Ghana used to be Ghana, labor officer is responsible. Labor officer is responsible. But now I will tell you for a fact that it is reverted to the employer. For instance, if Ghana Health Service staff fill this form, it gets to labor officer. And as I mentioned, the labor office takes percentage of the money is calculated. And their interest is that the money will be big so that they can also get big. So they will bring this to Ghana Health Service headquarters for Ghana Health Service accounts people to pay. Before, all these monies will be with labor office and labor officers will pay. Now, all these functions have been delegated to the specific ministries, agencies, and have to deal with it. If you are collecting full allowance from your hospital, you want labor officer to pay for your injury at the hospital? No. It will come back to the hospital or the service. If it is beyond the service, it goes to the ministry. And if it's beyond the ministry, then it goes to the Ministry of Finance. That's how it works nowadays. Just like if a hospital is sealed, now the hospital at the hospital level must find money to pay. If they can't pay, the region ought to see if they can do something to pay. If it is beyond the region, then it comes to national headquarters. And if they can't, it moves to the ministry and then to Ministry of Finance. Who signs the form? Every medical officer can sign because this form is there, but you should be careful. Little monies bring big problems. If you know it is severe injury related, orthopedic, and other areas, let's leave it to the specialists and let them take their fight. If you're a medical officer and you want to chop every morning, one morning you vomit, they will put you before a committee and dress you up. Well. The law says medical officer, simply medical officer. But would you be able to defend it? Do you have what it takes to defend it? Is it within your area? If the person is referred back for review, would you be able to do it? Let's look at all this. Sometimes you see even PA signing these forms. clearly stated medical officer.
Yeah.
Let's be careful.
Our General Secretary, Dr. Richard Salome, wants to ask a question. Dr. Salome.
General, I'm listening.
Thank you, Dr. Ankra, for the education, and we are very grateful. Maybe to move away from the claims a little bit. In recent times, at the Secretariat, we have had reason to be worried about some letters we receive sometimes from insurance companies, sometimes from certain other companies who have had to pay claims about doctors who are either going to what we call claims fraud, or sometimes they are overestimating claims, and some are going to some bad agreements with people behind the scenes so that they will get their cuts. What is your experience you share on this? What are the liabilities that come with this? For example, if I just go and estimate certain things in my notes, I don't document properly, and then they take me on and I cannot prove it. What are some of the consequences for me if as a medical doctor or dental practitioner in that regard? And what are some of the experiences you've had with some of these occurrences? Thank you.
And Dr. Salome, you've asked the very main question for this workshop. Why am I saying so? When I started, I said many employers call and ask, and they complain. And the main complainant is NITS because they pay a lot of compensation. And their complaint is that my people are writing a lot without basis. And that's what the previous question was. Who is supposed to write? If you overestimate and you can't justify it, if they just dress you up and they let you go and sin no more. But if they report you to medical and dental council, it's fraud. You may lose your license. They may report you to the police. And you can't justify it. You may stand trial. And you may go to prison. It has serious consequences. That is why I stated that small monies bring huge problems. That's small money that you are going behind to collect. And I am frank to say that many of our colleagues are just ignorant, not because of money. Many of them are not taking any money, apart from that small fee, 500,000, maximum 2,000, 5,000, specialist consultant. Now I do 5,000. They are estimating it out of sympathy. And I stated that it shouldn't be out of sympathy. They are estimating it because of relationship. It shouldn't be so. And that is why this law is there. It is termed as insurance fraud, but I can say and put my head on that my colleagues are not involved in insurance fraud. Doctors are not involved in insurance fraud. The people engaged in insurance fraud prey on their ignorance. Doctor, I won't feel away, mommy. Which was some mommy and baby do. Doctor will write out of empathy and sympathy. We all had the passion with which our prof, Dr. Holbrook Smith, was talking about. And this passion has entered all of us. So you do that, and the other person sitting elsewhere see only one motive: fraud, one term. And he's saying what? Fraud. They want to go behind and collect the money. I can say no. I fight this every day with insurance companies. But what happens? We must be very careful to write what we can defend. And as Dr. Salome, you said, documentation in our notes. If your report cannot reflect, if your note is called upon, then why did you fill the form without documenting? And this goes also with the police forms, medical forms, and all other forms. And now you know that this one is going for compensation. We ought to go by the book. And whatever we write, we must document and must be able to defend it. As I said, if the person is a footballer and has lost the function of the foot, yes, he can walk. But at the time of the injury, as the law says, he was a football player and he has lost his employment 100%. Yes, so you go and defend it before the board, the committee, and nobody will hold you accountable. You would be applauded. But when you are called to defend it, and you go there and that is not on. Because as a doctor, you are viewed as an intellectual scientist. Everything you write must have scientific basis and not by discretion. So please, Dr. Salome, if they bring that, don't throw them under the bus. Call them, ask them, and sometimes you'll be surprised that they are just ignorant. I can tell you that is the second time for the entire years I've worked that we are talking about Workman's compensation. The first one, I went to the Volta Regional GMA. This is more than 10, 15 years ago. It hasn't been part of our conversation, but it is creating a lot of problems. So please, the insurance companies must bear with us. We are not fraudsters.
So, Dr. Anka, thank you for that. Just to let you know that as an association, we never do that. But I can tell you of one instance where the company hired a private detective who had tracked meetings between a colleague and quote and unquote a claimant for that matter. The issue eventually went to MDC anyway. But that's why we are just advising, and we are happy the CPD committee of which I'm part of is doing this. Maybe we need a few more sessions of this to also educate us on the slippery slopes that will take some time when it comes to signing these forms and also allocating some of these things. So, of course, the association will never throw anybody under the bus, but it's just for us to know that these things are happening, and the companies will always try to cap their cost and will come at people. So we should be very careful when doing it. Thanks once again for the response.
Okay. So, Dr. Ankra, please, would you want to, highlight more on the issues as Dr. Salome said, or I should keep on with the questions? We have like 10 minutes.
I think you ask few questions. That one will come in the summary again, because that is what we started with. The question Dr. Salome asked is very important, so we have to summarize it. Summarize with it. So ask few questions more.
Okay, let me see. All right. So, Dr. Vincent Ativo is asking, could you talk about disfigurement and how one could assess it? And also, Dr. Ampofo is asking, the list is, this list seems not to exhaust neurosurgical injuries. How do we, for instance, call disability in a patient who had head injury and is now having that, say, memory loss or hemiparesis? And Dr. Kojo Lindsay is asking, if a person sustains a disability of, say, 60% and the same person sustain another disability at another area, say 70%, could the person be given 100% or the doctor can use his discretion?
I think I said that nobody is going to have more than 100%.
So he was saying,
the 60 and the 70 will end up having 100.
Oh, okay.
And not more.
Okay.
And the neurological question I think I've answered is the loss of function we are talking about. If the person had lost the right side of the body, hemiplegia, and cannot function in the work that he used to do when that happened. Let's be very specific. You see, it is the function that you were performing before the accident occurred, not what you want to do in future. You are an orthopedic surgeon. You are using your hand. You are a brofu carpenter. Now, your hands are no more there. You can walk, you can go everywhere. You can do whatever you want to do, but you cannot operate if lost 100% function. Yes, the pediatrician may still consult and do his work and hasn't lost anything. That is just disfigurement, and that is calculated by the board and paid for. But at the time of the injury, though two of you were in the same bus, sustained the same injuries, one may have 100% incapacitation and the other may not have it because that person may still continue functioning. It is the function. So we must be particular about that.
So Dr. Hadi Mohammed Abdullah is asking, what is your opinion about the quantum of money paid as compensation in Ghana when compared with other countries? 100% does not necessarily put adequate money for the care of a patient who with say complete spinal cord injury. And okay, can you kindly answer this question whilst I go through it?
Yes. I separated the care from the compensation. Let's not lump them together. It doesn't mean that when you are paid, the employer is absolved from taking care of you. I've said this, that taking care of the employee is not part of the compensation. Sending me to US for medical care is not part of the compensation. Say that when I come back, you say, by yourself, I sent you for this and that and that. That is your core responsibility. And then you pay the compensation separate. The compensation is not part of the medical care. So let's take note of that. So that somebody will not tell you that you've been compensated and therefore you cannot be taken care of. Because I've had one issue like that. Someone in one of our big companies, in fact, a doctor who lost the function of his legs and had been going to the US for treatment. The company they had taken him through care and therefore they are not going to do it again. I just had to threaten going to court. And then being advised by their lawyer, did the needful. Taking care of me is separate. You take care of me for that injury that I had sustained during the course of my work. Till. But compensation is paid once. So don't let us bog the two together.
So, Doc, we have like 7 minutes. So if you can, summarize or give us your closing remarks,
yes.
then. Yeah.
Yes, as I stated from the beginning, that this topic is very important and we must all take it very serious, especially the non-specialists who are interested in signing forms. If you are signing such a form, kindly take a look at the table, the Schedule 3 under the law, and go by it. And if you are not inclined to go by it, document and explain so that when you are called, you will be able to explain according to your notes. That is why I said that if you say that I've lost an eye and it's 100%, you should be able to say that the other eye is non-functional. That is why the functional one, the loss of the functional one, makes me attain the 100% because I cannot see. And all this must reflect in your notes because loss of one eye is not 100%. You need to record documents in your notes. Other than that, it will be taken as insurance fraud. Yes, there are a few ones that had come up that we know that they did it on purpose. But I can say that 99.9% of our colleagues are just ignorant, filling these forms out of empathy and sympathy. And they must avoid that because the consequences is not easy. If you are taken to medical and dental council, the stress of going to that place alone should deter you from doing the wrong thing before the ruling is given. Sometimes it takes years, and I will not advise anybody to just fill a form to go to medical and dental council to answer, or for insurance company to label you as a fraudster. So let's be careful in our dealings. Documentation is very important. Yes, the law says medical officer, but I stated clearly that you don't have absolute discretion to write anything you like or you feel like. You don't have discretion in that. And we must always have in mind the function and not just the organ. The function is very important. The loss of function. If you stick to that and the work that person was doing when that incident occurred, when you stick to that, you would always have it right. Thank you once again.
All right. Thank you very much, Dr. Ankra, for such an insightful and wonderful presentation. We are very honored to have you educate us on the legal aspects in our work. And also thank you to the CPD committee for bringing out such insightful topics, which are very relevant to our work. And most of my colleagues had questions to ask, but due to time, we are unable to read all of them, but we'll find ways and means of reaching out to you to answer their questions. So, Chairman, Dr. Hammond. Dr. Hammond. Hello, Dr. Hammond. I think we've lost Dr. Hammond on the call. So on this note, I would like to say a very big thank you for all those who are able to make time to join this wonderful presentation from Dr. Maurice Ankrah. And we will always knock on his door to, as in, give us such insightful presentations as the years go by. Dr. Salome.
Always welcome.
I think my chairman is not on the line, so if you would give us, as in the closing remark for the event. Dr. Salome.
Okay. On behalf of the chairperson of the committee, and then on behalf of the chairperson for the day, Dr. Hammond, and indeed on behalf of the entire association, I would like to say thank you to Dr. Maurice Ankrah for the presentation, practical examples, and also making time to spend this long time online with us. To our members too, we thank you that at every time that we organize these CPDs, beyond just coming to acquire points, you stay engaged and ask insightful questions and make the discussions lively. We believe that there will be even more sessions on this topic to come so that we can delve a little bit more to address the questions that were not addressed. And hopefully we'll see you again at the next CPD session, which will also discuss issues regarding some more practices, unethical practices that are creeping into our profession. And we believe that we would have an honest discussion on that one as well to inform ourselves and prevent ourselves from getting into various tricky situations. So thank you, everyone, and let's have a very pleasant evening.
Thank you very much, Dr. Salome. Have a wonderful day, ladies and gentlemen.